Excellencies, distinguished guests, ladies and gentlemen, good morning, good afternoon and good evening, and welcome to this IMO ITLOS Workshop. We shall have an insightful panel discussion on the legal aspects of vessel arrests, flag state rights, ship registration and the procedural frameworks under international maritime law. But to begin proceedings, it gives me great pleasure to invite the Secretary-General of IMO, Mr. Arsenio Dominguez, for his opening remarks. Please.
Good afternoon. It's a graveyard hours right after lunch, so I need to make sure that you're all here with us this afternoon. It's great to see a very full room of experts and interested participants. Excellencies, distinguished delegates, ladies and gentlemen. Welcome all to this joint event, bringing together experts representing IMO and the International Tribunal of the Law of the Sea. ITLOS is an independent judicial body established by the United Nations Conventions of the Law of the Sea. And when UNCLOS was adopted back in 1982, IMO already had in place a comprehensive body of international conventions covering safety, efficiency, and environmental performance of international shipping, as well as search and rescue, liability, and compensation. That is why many articles of UNCLOS refer to the legal framework developed by a competent international organization, and therefore IMO treaties are referred to in many provisions of UNCLOS. There are clear linkages between the judicial work of ITLOS on maritime matters and the work of IMO. A recent example is the submission provided by IMO towards the development of the ITLOS Advisory Opinion on Climate Change and the Ocean. I am delighted to welcome today to IMO Mr. Thomas Hader, President of ITLOS, who of course will speak to you on this important advisory opinion. Following Mr. Hader's insights, you will hear from panelists on other critical matters, namely the arrest on and registration of vessels. I'm sure that with a room full of legal experts, there will be plenty of insightful questions and further discussions later on as you continue the conversations in the Delegates' Lounge. And on that note, I would also like to express my appreciation to Cyprus for generously hosting the evening reception right after this event. And with that, thank you very much. And do have an active participation in the event today. Thank you.
Thank you, Secretary-General. I now have the honour to invite Judge Thomas Hader, President of ITLOS since 2014, also Director of the Law of the Sea Institute in Iceland, and Co-Director and Lecturer of the Rhodes Academy of Oceans Law and Policy, to address you. Please.
Mr. Secretary-General, Excellencies, ladies and gentlemen, it's really nice to be back in London. I used to live here until recently and see so many of you here. I know that this is the best time of the year in London. The trees are blooming, and so I'm sure it's a challenge for each and every one of you to be inside in this spring weather. It is a pleasure for me to address you today at this workshop jointly organized by the International Tribunal for the Law of the Sea and the International Maritime Organization and sponsored by the government of the Republic of Cyprus. At this workshop, a number of important matters relating to the arrest and the registration of vessels will be discussed. These issues have been central to cases before the tribunal and are of significant importance to the work of the IMO. Their continued examination and understanding are vital for ensuring legal certainty, strengthening ocean governance, and supporting the sustainable and efficient management of international shipping. The IMO, as we all know, plays a crucial role in setting global standards for the safety and security of international shipping. It has, however, also a long and successful record of addressing the prevention of marine pollution from vessels. More recently, the IMO's efforts to address greenhouse gas, or GHG, emissions from vessels, such as the 2023 IMO strategy on reduction of greenhouse gas emissions from ships, are particularly significant in the collective fight against climate change. This issue is also at the heart of the advisory opinion on the request submitted by the Commission of Small Island States on Climate Change and International Law, or COSIS, which the Tribunal delivered unanimously on 21st May last year. Given the importance of climate change, I would like to use the opportunity today to briefly take you through the Tribunal's advisory opinion, and in doing so, highlight some aspects that directly relate to the work of the IMO and the obligations of flag states in particular. Before discussing the Tribunal's findings, let me recall that on 12 December 2022, the Commission of Small Island States on Climate Change and International Law, COSIS, submitted a request to the Tribunal for an advisory opinion on 2 questions. And I may add that during my speech, I will refer to the 1982 United Nations Convention on the Law of the Sea simply as the Convention. For us in Hamburg, there is only one convention. The first question was formulated as follows. What are the specific obligations of states parties to the Convention, including under Part 12, to prevent, reduce and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change, including through ocean warming and sea level rise, and ocean acidification, which are caused by anthropogenic greenhouse gas emissions into the atmosphere? This first question focuses on marine pollution, and in particular on Article 194 of the Convention. The second question was phrased as follows. What are the specific obligations of states parties to the Convention, including under Part 12, to protect and preserve the marine environment in relation to climate change impacts, including ocean warming and sea level rise, and ocean acidification? This question is broader than the first question, and in fact covers the first question as well, because this one is related to the general obligation to protect and preserve the marine environment, which in principle also includes pollution. I think the reason why COSIS decided to ask not only the first question but also the second question was probably that they wanted to have both a belt and suspenders. If we had not concluded in responding to the first question that anthropogenic greenhouse gas emissions constitute pollution of the marine environment, we would still have to respond to this second question, which applies irrespective of whether we could consider this as pollution or not. The significance of this case is evident from the level of participation in the proceedings before the Tribunal. Written statements from 34 states parties and 9 intergovernmental organizations, including the IMO, were submitted as part of the case file. Furthermore, 33 states parties and 4 intergovernmental organizations made oral statements during the proceedings. This broad participation reflects the widespread interest in clarifying the obligations of states parties under the Convention in the context of climate change. In the advisory opinion, the Tribunal addressed several important points. The first aspect I would like to highlight concerns the relationship between the Convention and other relevant rules of international law, that is, external rules, rules found outside of the Convention. In this regard, the Tribunal found that there is an extensive treaty regime addressing climate change, including, among other instruments, the United Nations Framework Convention on Climate Change, the UNFCCC, the Kyoto Protocol, and the Paris Agreement. It considered that, in the case before it, relevant rules external to the Convention may be found in particular in these agreements. Let me highlight that the Tribunal also cited Annex 6 to the IMO's International Convention for the Prevention of Pollution from Ships, or MARPOL, as an agreement in which relevant external rules may be found. This annex, as you know, deals with the prevention of air pollution from ships, and the Tribunal specifically referred to two amendments to Annex 6 adopted in 2011 and 2021. The 2011 amendments were made with a view to reducing GHG emissions from ships through the inclusion of regulations concerning energy efficiency. The 2021 amendments aimed to reduce carbon intensity of international shipping, working towards the levels of ambition set out in the initial IMO strategy on the reduction of GHG emissions. The Tribunal also noted the 2023 IMO strategy on reduction of GHG emissions from ships, which identifies a set of levels of ambitions for the sector, notably to peak GHG emissions from international shipping as soon as possible and to reach net zero GHG emissions by or around 2050, taking into account different national circumstances. With regard to the relationship between the Convention and external rules, the Tribunal emphasized the relevance of coordination and harmonization between them. In its view, this is important to clarify and to inform the meaning of the provisions of the Convention and to ensure that the Convention serves as a living instrument. In this context, the Tribunal identified three mechanisms through which the relationship between the Convention and other rules of international law is formed. First, through rules of reference in certain provisions of the Convention that explicitly refer to external rules, in particular in Part 12 of the Convention. Second, through the openness and mutual supportiveness between Part 12 of the Convention and other treaties on marine environmental protection, as outlined in Article 237 of UNCLOS. And third, through Article 31.3c of the Vienna Convention on the Law of Treaties, which requires that account be taken, together with the context of any rules of international law applicable in the relations between the parties. This is the so-called systemic integration, this principle of the Vienna Convention, really at the heart of the advisory opinion. Excellencies, ladies and gentlemen, there is another closely related aspect of the advisory opinion which I would like to highlight. Fundamental to the Tribunal's considerations was the question whether anthropogenic GHG emissions constitute pollution of the marine environment. Even though the term GHG, or climate change, or ocean acidification for that matter, do not appear in the Convention. In dealing with this question, the Tribunal built on the idea of the Convention as a living instrument. Allow me to illustrate this point. Article 1 Article 1, paragraph 1, subparagraph 4 of the Convention defines the term pollution of the marine environment. As the Tribunal clarified, this definition does not provide a list of pollutants or forms of pollution of the marine environment, for example, by naming oil pollution, radioactive waste pollution, plastic pollution, etc. That was not the approach taken by the negotiators of the Convention. Instead, the article sets out three criteria to determine what constitutes such pollution. First, there must be a substance or energy. Second, this substance or energy must be introduced by humans, directly or indirectly, into the marine environment. And third, such introduction must result or be likely to result in deleterious effects to the marine environment. The Tribunal then applied these criteria to anthropogenic GHG emissions. First, by interpreting the terms substance, energy, and gas in accordance with their ordinary meaning and taking into account relevant definitions from the UNFCCC and the Intergovernmental Panel on Climate Change, the IPCC, reports, the Tribunal concluded that GHGs qualify as substances. Accordingly, the first criterion of the definition of pollution of the marine environment under the Convention is satisfied. Second, in view of the definitions of emissions in UNFCCC and anthropogenic emissions in IPCC reports, the Tribunal concluded that anthropogenic GHG emissions are clearly produced by humans. The Tribunal further clarified that the term marine environment encompasses both spatial and material dimensions, including ecosystems and the interconnected physical and biological components of the ocean, and that the introduction of GHGs into the marine environment can occur both directly and indirectly. Accordingly, anthropogenic GHGs emissions satisfy the second criterion of the definition of pollution of the marine environment under the Convention. Third and final, referring to UNFCCC and IPCC reports, the Tribunal found that the introduction of anthropogenic GHGs into the marine environment causes ocean warming and ocean acidification, both of which result in the deleterious effects described in the Convention's definition of pollution of the marine environment. Accordingly, the third criterion is also satisfied. Now, having determined that all three criteria were satisfied, the Tribunal concluded that anthropogenic GHG emissions into the atmosphere constitute pollution of the marine environment under the Convention. The significance of these conclusions should not be underestimated. It reinforces the continued relevance of the Convention in addressing contemporary challenges in the law of the sea, and in particular highlights the role of the Convention as the primary legal framework for addressing marine pollution, including pollution caused by anthropogenic GHG emissions. Since it cannot simply be presumed that state parties' obligations under the Convention apply to climate change and ocean acidification, this finding lays the groundwork for the Tribunal to clarify states parties' specific obligations to prevent, reduce, and control marine pollution caused by anthropogenic GHG emissions from various sources, including vessels. This brings me to a further aspect of the advisory opinion that I wish to address, namely the obligations of states parties to the Convention, including flag states, to prevent, reduce, and control marine pollution caused by anthropogenic GHG emissions. Let me say, however, that the advisory opinion is an extensive document, and I will not be able to present to you here all the obligations that it refers to. I will rather highlight some of them which seem to be particularly pertinent. The Tribunal found that Article 194, Paragraph 1 of the Convention imposes an obligation of states to take all necessary measures to prevent, reduce, and control marine pollution caused by anthropogenic GHG emissions. These necessary measures should be understood broadly. They include those designed to minimize, to the fullest possible extent, the release of toxic, harmful, or noxious substances, especially those which are persistent. Science, the Tribunal noted, plays a crucial role in determining what those necessary measures should be. However, it also underlined that scientific certainty is not required. In the absence of scientific uncertainty, states must apply the precautionary approach when regulating marine pollution from GHG emissions. In the context of climate change, this approach is essential because the potential harm caused by these emissions can be serious and irreversible. Relevant international rules and standards, particularly those set out in global agreements on climate change, also play a crucial role in assessing necessary measures. In the advisory opinion, the Tribunal in particular clarified the relationship between the Convention and the Paris Agreement. The Tribunal noted that the temperature goal and the timeline for emission pathways set out in the Paris Agreement inform the content of necessary measures to be taken under Article 194, Paragraph 1 of the Convention. However, the Paris Agreement does not require the parties to that agreement to reduce GHG emissions to any specific level according to a mandatory timeline, leaving each party to determine its own national contributions. The Tribunal emphasized that compliance with obligations and commitments under the Paris Agreement alone does not fulfill a state's obligations under the Convention. States remain legally bound by Article 194, Paragraph 1 of the Convention to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic GHG emissions, and failure to do so may result in international responsibility. According to the advisory opinion, the Convention and the Paris Agreement are separate agreements with separate sets of obligations. While the Paris Agreement complements the Convention in regulating marine pollution from anthropogenic GHG emissions, it does not supersede the Convention. In the view of the Tribunal, the Paris Agreement is also not lex specialis to the Convention. However, as stated by the Tribunal, even if it had an element of lex specialis to the Convention, it nonetheless should be applied in such a way as to not frustrate the very goal of the Convention. The Tribunal also clarified that the obligation to prevent, reduce, and control marine pollution caused by anthropogenic GHG emissions is one of due diligence. In this connection, the Tribunal noted that best available science informs that anthropogenic GHG emissions pose a high risk in terms of foreseeability and severity of harm to the marine environment, and that there is also broad agreement within the scientific community that if global temperature increases exceed 1.5 degrees Celsius compared to pre-industrial levels, severe consequences for the marine environment would ensue. In light of such information, the Tribunal considers that the standard of due diligence states must exercise in relation to marine pollution from anthropogenic GHG emissions needs to be stringent. I also wish to highlight that the Tribunal in the advisory opinion clarified that Article 194, Paragraph 2 of the Convention imposes a special obligation on states parties to take all measures necessary to ensure that activities under their jurisdiction do not cause damage by pollution to other states and their environment, and that pollution arising from their activities does not spread beyond the limits of their national jurisdiction. The phrase activities under their jurisdiction or control, as the Tribunal explained, refers to activities carried out by both public and private actors. Activities carried out on board ships or aircraft which are registered in a state may also be considered activities under the jurisdiction of that state. This obligation is also one of due diligence, and with respect to transboundary pollution affecting the environment of other states, the standard of due diligence can be even more stringent than under Article 194, Paragraph 1. The Tribunal also considered the issue of marine geoengineering. It found that marine geoengineering would be contrary to Article 195 of the Convention if it has the consequence of transforming one type of pollution into another. Marine geoengineering may also be subject to Article 196, which requires states to take all necessary measures to prevent, reduce, and control marine pollution resulting from the use of technologies under their jurisdiction or control. In this regard, the Tribunal acknowledged that geoengineering has been the subject of ongoing discussions, including under the Convention on the Prevention of Marine Pollution by Dumping of Wastes and Other Matter, 1972, and its 1996 protocol. And here I'm referring to the London Convention and the London Protocol. Furthermore, the Tribunal identified obligations of states applicable to different sources of pollution, including pollution from land-based sources, vessels, and the atmosphere. In this connection, I will briefly highlight the clarifications offered by the Tribunal with regard to marine pollution from vessels. First, under Article 211, Paragraph 2 of the Convention, states have the obligation to adopt laws and regulations to prevent, reduce, and control marine pollution from vessels flying their flag or of their registry. The Tribunal underscored that the obligation under this provision is incumbent on the flag state and that the laws and regulations referred to therein must at least have the same effect as that of generally accepted international rules and standards. The Tribunal noted that the term generally accepted international rules and standards is not defined in the Convention. It explained that such rules and standards may refer to those contained in international legal instruments that are accepted by a sufficiently large number of states, and that they must be established through the competent international organization or general diplomatic conference. In this regard, the Tribunal clarified that the term the competent international organization is understood to refer to the IMO. It also noted in this context that the IMO has adopted the amendments to Annex 6 to MARPOL, which I already mentioned earlier. Second, the Tribunal referred to Article 217 of the Convention, which provides for enforcement by states with respect to marine pollution from vessels flying their flag or of their registry. Under paragraph 1 of that article, states need to ensure that such vessels comply with applicable international rules and standards and their laws and regulations. The provision also clearly indicates that flag states shall provide for the effective enforcement of such rules, standards, laws, and regulations, irrespective of where a violation occurs. Excellencies, ladies and gentlemen, before concluding my remarks on the advisory opinion, let me now briefly turn to the second question submitted by COSIS. In its response thereto, the Tribunal made it clear that, pursuant to Article 192 of the Convention, states parties have a specific obligation to implement measures to protect and preserve the marine environment in relation to climate change impacts and ocean acidification. The advisory opinion further clarifies that states parties must protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, or endangered species and other forms of marine life from climate change impacts and ocean acidification. They are also required to take necessary measures to conserve living marine resources threatened by climate change impacts and ocean acidification by applying the precautionary approach and an ecosystem approach. In this regard, the Tribunal recognized area-based management tools, including marine protected areas, or MPAs, as a potential response strategy to climate change. The Tribunal further noted that while the term marine protected area is not explicitly found in the Convention, Part 12 does not preclude states from adopting more stringent measures to protect and preserve the marine environment, provided they remain consistent with the Convention and other rules of international law. Mr. Secretary General, Excellencies, ladies and gentlemen, the Tribunal's advisory opinion on climate change and the ocean is a milestone in clarifying the obligations of states parties under the Convention in the face of one of the most pressing challenges of our time, climate change and its impact on the marine environment. It reaffirms that the Convention is not a static treaty, but a living instrument capable of addressing evolving environmental threats. It provides much-needed clarity on the obligations of states parties to prevent, reduce, and control marine pollution caused by anthropogenic GHG emissions from various sources, including from vessels. Flag states in particular have a specific obligation to ensure compliance by vessels with international standards, and the IMO's work in setting these standards is pivotal. Looking ahead, it is clear that fulfilling these obligations will require not only determined action by individual states, but also meaningful cooperation between them. The advisory opinion offers valuable guidance on how obligations under the Convention should be implemented, including in light of relevant international instruments such as those developed by the IMO. Thereby, the advisory opinion contributes to ensuring the protection of the marine environment for current and future generations. I have now come to the end of my keynote address. I'll be happy to answer any questions that may arise or listen to comments. On behalf of the Tribunal, I wish to express my sincere appreciation to the IMO for co-organizing this workshop with ITLOS and for the generous hospitality. I look forward to the engaging discussions ahead. Thank you for your kind attention.
No questions? No? Thank you.
Thank you.
Thank you very much. Thank you, Mr. Hader. So, ladies and gentlemen, let's now turn to the first part of our panel discussion, and I wish to introduce the first moderator, Ms. Nihan Unlu, Deputy Director of the Legal Affairs and External Relations Division at IMO. Thank you, Nihan.
Thank you, Tamara. Good afternoon. It was a tiring day for you, but the panel discussions will be so interesting, and I think you will cheer up again after the legal committee. So the first panel today will be discussing very interesting topics on arrest of vessels, key aspects of ITLOS case, law and procedures. We have very distinguished panelists, and I will start first with Dr. Elizabeth Lynchzat. Perfect. And I will say Elizabeth, without saying your surname from now on, is a judge at the International Tribunal of the Law of the Sea and a member of Seabed Disputes Chamber. She is a member of the Permanent Court of Arbitration as well. Since 2021, she chairs the supervisory board of the TMC Asser Institute in The Hague. Previously, she was the principal legal advisor on public international law at the Dutch Ministry of Foreign Affairs and head of its international law department. Elizabeth is also Professor Practice of International Law at Maastricht University. Today, Elizabeth is going to give a presentation on the right of the flag state to make claims in respect of arrested vessels, the concept of ship as a unit. The floor is yours, Elizabeth.
Thank you very much, Nihan, and I too would like to thank the IMO and Cyprus for organizing this meeting and seeing so many of you in this room. Happy to see so many colleagues, excellencies, ladies and gentlemen. I'm going to talk to you a little bit about what is known as the ship as a unit rule. Now, this is a very old picture, and I'll explain to you why we have the pleasure of having this black and white picture on the screen at the moment. Let me summarize what I'm going to talk about. The ship as a unit, sorry, we have to make sure that we act in a coordinated manner. Thank you. The ship as a unit is a rule that pertains to the domain of the nationality of claims. And it goes to the question of which state is entitled to represent not only its own interests, that is the interests vested in the nationality of the ship, but also the interests vested in the nationality of ship's crews. And I certainly, to an IMO crowd, do need to explain to you that there are so many different nationalities on board of ships these days. Now, the nationality of claims traditionally is about issues like diplomatic protection, which can be extended to people having the nationality of that state, natural persons, but also legal persons, corporations and the like, and ships flying the flag of that particular state. Also, important to keep in mind, the extension or the application of diplomatic protection is a discretionary right. It means that the state of nationality has the possibility to act in litigation for its national, but that it is not obliged to do so. So acting on behalf of its national with respect to acts that are potentially contrary to international law. Who can represent the claim on behalf of the ship before an international judicial body? But fundamental question, does that also include the rights of the crew who may belong to another state? Now, the ship as a unit rule is a sort of an abbreviated version of a procedural rule about the representation of the ship and the crew before the tribunal and before other courts. Traditionally, the ship is represented by the flag state, but as I said, that is discretionary. However, the crew is increasingly international, there is a diversity of nationality, so which state, has to represent the crew in litigation. Now, the ship we just saw is the I'm Alone, and this goes back to a case from 1929. I think it's one of the earlier cases known for the ship as a unit rule. And the I'm Alone, just to give you a little bit of a background, the I'm Alone is a so-called rum runner during the period of prohibition in the United States. So the ship is smuggling liquor which is strictly prohibited in the period of 1920 to 1933, and it is caught when it is on a trip from Belize to the United States, presumably carrying rum, which is prohibited at that point. The owners of the ship are American, but the ship is registered to Canada. And the US Coast Guard tries to stop the ship off the coast of Louisiana, but the ship fails to stop, so eventually the ship is sunk by the US Coast Guard. As you've seen, it's not a very big ship, and it has a crew of 8 persons who end up in the water, obviously, and 1 person drowns in that accident. Excuse me. All the others are saved, but the 1 person who drowns happens to be a French national. Now, there is a commission procedure about the arrest and sinking of the ship, in which Canada demands damages for the loss of the ship, but also for the loss of the French crew member. Now, this is intriguing from the traditional perspective. Diplomatic protection is possible for your nationals, but those nationals would have been the Canadians who ended up in the water but all survived. Question mark. That's strange. Why is Canada acting on behalf of the French crew member? And what is even more interesting is that the commissioners, it's a kind of an arbitration case, the commissioners don't make a point of it. So it's noticeable, Canada acts on behalf of that one Frenchman, and that is connected to the fact that the ship was registered in Canada. Right. Fast forward some 70 years later, the Saiga 2 case, which is one of the first cases of before the tribunal in 1999. This is when this concept of a ship as a unit enters into the case law of the tribunal, and it is again about who has the possibility to act on behalf of crew members that do not have the same nationality as the flag state. It comes up, it's a provisional measures case, it comes up as a challenge to admissibility. And this is important because if the defendants are successful in their challenge to the admissibility, the case is likely to disappear. So what happens is, this is a case about bunkering in fisheries, and what happens is that a ship with a nationality of St. Vincent and the Grenadines is arrested in the EEZ of Guinea. And looking at the nationality of the people on board, there are majority are Ukrainians, and there are 2 painters from Senegal on board. The ship has a nationality of St. Vincent and the Grenadines. There is a cargo interest from Switzerland as well. So starting with paragraph 103, the tribunal starts to discuss the nationality of claims, and then the crucial paragraphs are 105 all the way to 107. In 105, the tribunal makes the point that in 2 provisions of the convention dealing with the duties of flag states on the high seas, that's Article 94 of the convention, and Article 217, which is about the enforcement by the flag state in Part 12 of the convention, none of these provisions make a distinction between national and non-nationals of a flag state. So what the tribunal is essentially saying is these obligations are aiming at the role of the flag state without making a distinction between the nationals or non-nationals of the flag state on board of the ship. So essentially saying the nationalities of the crew, the people on board, are not really relevant for bringing a claim on the basis of the nationality of the ship, also dealing with the interests of the seafarers. And that leads to a fairly straightforward message in paragraph 106. Thus the ship, everything on it, and every person involved or interested in its operation are treated as an entity linked to the flag state. So it may be that St. Vincent and the Grenadines is the flag state, but they can spread their wings and, as it were, also cover the interest of Ukrainian crew members and the 2 Senegalese painters that were on board of the ship. And then they add to that in paragraph 107, and I think with a great sense of realism, the tribunal must also call attention to an aspect of the matter which is not without significance in this case. This relates to the 2 basic characteristics, the transient and multinational composition of ships' crews of modern maritime transport, and the multiplicity of interests that may be involved in the cargo on board a single ship. So the tribunal is well aware that restricting the possibility to act before the tribunal to only the national state of the ship, so the flag state, would be almost running contrary to the reality of maritime transport. And it continues to say, any of these ships could have a crew comprising persons of several nationalities. If each person sustaining damage were obliged to look for protection from the state of which such person is a national, undue hardship would ensue. Now, I think the logic behind that comment is that very often you see that when a state takes action, takes steps towards the state under a flag, towards a ship under the flag of another state, the situation of the crew and the people on the ship is largely influenced by whatever the acting state, normally the coastal state, anyway, the state that takes action, what the state that takes action does with respect to the ship will be of great influence to the situation of the people on board. You very often see the ship is arrested and either the crew can't leave the ship, they cannot go on land because the ship is arrested, or the other variety that you see is the ship is arrested and the people on board are taken and are being detained. So it is a bit about the fate of the ship and the fate of the people on the ship seem to go together. This is sort of a rationale underlying this notion of the ship as a unit. We move ahead. In the meantime, the International Law Commission, which, as you may know, is a specialist organ of the UN General Assembly, working on the codification and the development of international law, they are looking at the law of diplomatic protection, which is up to then mostly customary law, and the sense is it would be very helpful to start to write down this law. And there in Article 18, we see that the ILC is also looking at this ship as a unit idea. It is in, I must add, it is in a specific part of the articles of the ILC on diplomatic protection, which have been established in 2006, so that is more or less 7 years after the SIGAT II decision, where it tells us the right of a state of nationality of the members of the crew of a ship to exercise diplomatic protection is not affected by the right of the state of nationality of a ship to seek redress on behalf of such crew members, irrespective of their nationality, when they have been injured in connection with an injury to the vessel resulting from an international wrongful act. This is, in a way, starting at the other end of the question. It is raising the question, well, if the flag state is able to act not only on behalf of the vessel, but the flag state may extend its representation to the crew on board of the ship, does that mean, this is the perspective from the ILC, does that mean that the national state of the crew members is barred from doing so? And the ILC says no. It is still possible for the state of nationality of the crew members sitting on the ship that has been arrested to provide diplomatic protection to their nationals. And if you read the commentary, that implies that the ILC is theoretically looking at a concept in which the flag state exercises its authority relying on the ship as a unit role to extend their protection through litigation to also non-nationals through the ship as a unit rule. But at the same time, if the national state of the crew members wants to exercise diplomatic protection, that is also possible. So we end up with a kind of a system where you see concurrent or maybe parallel types of protection by the flag state and the state of nationality. However, ILC makes it absolutely clear that reliance on this ship as a unit rule, this is not diplomatic protection, but it is discretionary. I don't think it has happened often, at least I'm not aware of a case, where the flag state has intended to also extend its protection to non-nationals on the ship, and the national state has also said, oh, by the way, I want to give diplomatic protection. I don't know of a case, but if we follow the thinking from the International Law Commission, this might be theoretically possible, and I suspect, but that is particularly, I think, talking as a practitioner, I suspect that in a case like that, it would be wise for the flag state and the state of nationality to get together and figure out together what would be the best form of protection. So this is, in a way, sidestepping a little bit the development of case law, but then as we see things develop at the tribunal, a next case is the case of Virginia G, which is again about the bunkering of fishing vessels, where in paragraph 126 in the decision, this is a contentious case, by the way, it's not provisional measures. In paragraph 126, the tribunal verbally quotes what has been said before in SIGA 2, and in 127, the tribunal finds that the Virginia G is considered to be considered as a unit, and therefore the MV Virginia G, its crew and cargo on board, as well as its owner and every person involved and or interested in its operations, are to be treated as an entity linked to the flag state. My conclusion is that by the time we get to 2014, the rule of the ship as a unit is an established rule. And just for your information, the crew on board of the Virginia G is a 11-person crew. 7 are from Cuba, 3 are from Ghana, and 1 is from Cabo Verde. So here you see also this effect of a multitude of nationalities apart from Panama, which is the flag state. Right. I'd like to continue towards the end of what I wanted to say in pointing you to the case of the San Padre Pio, which is a case from 2019. It's also a provisional measures case of Switzerland as a flag state versus Nigeria. And the San Padre Pio is a tanker registered in Switzerland, which has been intercepted and arrested by the Nigerian Navy in relation to ship-to-ship transfer of gas oil in the Nigerian EEZ, and it has been taken to port in Port Harcourt. The crew, 16 persons, is arrested and detained, and later on in the storyline, criminal charges are later limited to 4 officers who have the Ukrainian nationality, and they are the only ones who remain in prison. The rest of the crew returns to the ship. The officers are later on bailed and returned to the ship, but they're not allowed to travel outside of Nigeria because, according to Nigeria, further court proceedings are to take place. Now, since this is about provisional measures, in provisional measures, there's always a sense of urgency, and what is particularly urgent in the view of the tribunal is the detention of crew members. That is something that is always of primary importance. But here's something, well, I would say interesting happens, and it is looking at the text again in preparation for today. The text is not very easy to read. First of all, and you really have to start reading in paragraph 1c, Nigeria is ordered to release the ship, the cargo, the master, and the 3 officers, so those are 4 Ukrainian nationals, and to ensure that the San Padre Pio cargo master and the 3 officers are allowed to leave the territory and maritime areas under the jurisdiction of Nigeria. Then we move on, top of the slide, to the obligation, or at least the wish that is expressed, that Switzerland shall undertake to ensure that the master and the 3 officers are available and present at the criminal proceedings in Nigeria. If the arbitral tribunal, that is to follow after these proceedings, finds that the arrest and detention of the San Padre Pio, its cargo, its crew, and the exercise of jurisdiction by Nigeria in relation to the event which occurred do not constitute a violation of the convention. So, first of all, the obligation for Nigeria is to let the ship and the crew go, provided Switzerland provides a bond. And then there is a request for Switzerland to undertake to ensure, so that is a kind of a low level of due diligence, I think, type of obligation, that the master and the 3 officers are available and present at criminal proceedings in Nigeria. Now, this is perhaps stretching the ship as a rule thinking a bit too far, because after all, the 4 Ukrainian crew members are not really under the control of Switzerland. The ship is Swiss, but if we follow what little 1.c says, there the crew is allowed to leave the territory and maritime areas of the jurisdiction of Nigeria. The more I think about it, the more I think this is something that we need to think through, and I would like to conclude with not just conclusions, but perhaps some more general issues to reflect about. So this ship as a unit is a procedural rule about the representation of ship and crew by the flag state, which we can say is now accepted as case law. We also know, that is what the International Law Commission has stated, that the state of nationality of the individual crew members retains the right to diplomatic protection for individuals, but further questions arise, as I just alluded to. Is the ship as a unit purely a procedural rule, or does it have a broader impact? As you may, this is, I think, one of the questions that arises from the San Padre Pio case. And by the way, who is it that belongs to the crew? All persons on board? Or what do we think if the ship at issue is a cruise ship? So the crew, to my mind, would be the people that are engaged in navigation and engaged in maintenance, the cook, maybe the painters. But how broad can we stretch this? And taking it even a little bit further, does this ship as a rule, a ship as a unit rule, does that also imply the protection of a crew member against its own state of nationality? So imagine a ship with a flag of A is arrested by state B, and the ship, including crew and cargo, etc., does contain a few nationals of state B. And then they're towed away to the port in faraway land. And then, of course, the ship, state B says, hey, those 2 are my nationals, I'll deal with them. And I have jurisdiction to do that. What happens exactly with the protective power of the flag state? Now, those are, I'm referring to further questions that I have not yet seen in real case law, but I think those are interesting suggestions, interesting types of cases to further explore. So with that, I'll close my presentation for today. Thank you.
Thank you, Elizabeth. It was truly engaging presentation. It was really interesting. So let me try to summarize what I understood a little bit, tiny, just one sentence. So the ship as a unit principle applied to ship as a whole rather than separate components. Correct, right? And so the questions also arise for the crew in that respect. If there are any issues in detention, it should be under this rule. The flag state should be responsible. But the issue is now also whether the crew's state of the nationality, this will be some engagement as well, has to be looked at, right? But ship as a unit should be, we should consider as a whole, not separate components as ship or the crew. That's the whole idea. Right?
Yeah. I think the whole debate starts out as a procedural rule. It's about who is doing the representation before court. So it may be that a ship is in trouble and the owner of the ship, or sometimes an NGO, if it is a ship owned by an NGO, they will approach the authorities of the flag state. Help me out. So first thing the flag state does is have another look at what kind of ship is this, what are our interests, should we take action or not. As I said, it's discretionary. Yeah? You have, as a ship owner, you have no right to diplomatic protection, but you can try and persuade the flag state. With respect to the crew, there is another state who also may have the right to provide protection directly, because my natural person with my nationality, I can provide diplomatic protection. Again, that's discretionary. But it looks a bit disorganized. If some states from the national states of the individual crew members do extend protection, others don't. But how likely that is, I don't know.
Thank you for further clarification. And of course, do you have any questions? I will come to you. Normally, I will have the questions after the second panelist, but I don't want you to forget the ideas. That's the reason I think I ask now, but you can always do it after the second presentation. So, all right, so let's start with our second presentation. Dr. Jimena Henry previously held various positions in the tribunal and ultimately serving as its registrar since 20 September 2019. In addition to her professional work, she has been a lecturer at several prestigious institutions, some of which are Hamburg University Applied Sciences, Hafen City University, University of Bremen, International Maritime Law Institute. Additionally, she has taught the Law of the Sea course at the World Maritime University from 2019 to present. She is the author of various publications on the law of the sea and international law. Jimena's presentation is on procedural aspects, provisional measures, and prompt release of vessels and crews. The floor is yours.
Thank you very much, Mr. Secretary General, Excellencies, ladies and gentlemen. It is a great pleasure for me to address you this afternoon at this workshop. And I believe it is of interest to delegates of this IMO legal committee to get insight into procedural mechanisms available to states before the tribunal to seek the release of vessels and crews. And with this in mind, in my presentation, I will address two different procedures. First, prompt release of vessels and crews under Article 292 of the Convention, ITLOS, and the prescription of provisional measures under Article 290. I will begin with a prompt release, a procedure which has no precedent in international adjudication. Its purpose, according to the tribunal, it has so stated in its jurisprudence, I quote, is to reconcile the interest of the flag state to have its vessel and its crew released promptly with the interest of the detaining state to secure appearance in its court of the master and the payment of penalties, end of quote. Under Article 292, this procedure applies when a vessel has been detained and it is alleged that the detaining state has not complied with the provisions of the Convention for the prompt release of the vessel or its crew upon the posting of a reasonable bond or other financial security. According to the Tribunal's jurisprudence, the relevant provisions are Article 73, paragraph 2, Article 220, paragraph 6, and Article 226, paragraph 1b of the Convention, which relate to fisheries offenses and in the exclusive economic zone of the coastal state in violation of international rules and standards on marine pollution, respectively. Therefore, the powers of the tribunal to deal with the release of vessels and crews would be limited to those situations. In addition, for this procedure to apply, both the detaining state and the flag state must be state parties to the Convention. Article 292 confers on the tribunal a residual and compulsory jurisdiction to order the release of a vessel and its crew, indeed failing agreement within 10 days from the time of detention to submit the question of release to any court or tribunal agreed upon the parties. The flag state can file an application for release before ITLOS at any time after the expiration of the 10-day time limit. In such situation, the tribunal is called upon to exercise its jurisdiction independently of any choice of procedure made under Article 287. However, the scope of the jurisdiction of the tribunal is limited because it is confined only to the question of release, bearing in mind that the tribunal's decision of release is without prejudice to the merits of any case before the appropriate domestic forum in respect of the vessel, its owner, or its crew. Furthermore, the authorities of the detaining state remain competent to release the vessel or its crew at any time. Another striking feature of this procedure is that the application may be brought to the tribunal by or on behalf of the flag state. In light of this wording, private entities such as ship owners, if duly authorized by the flag state, may appear before the tribunal. The tribunal treats applications for prompt release as a matter of urgency, for which they have priority over all other proceedings before the tribunal. Now, once an application for prompt release has been filed, the tribunal must deal with it without delay. Accordingly, in its rules, the tribunal has provided for short time limits for the written statement by the detaining state and the hearing, as well as the delivery of the decision, which is usually issued within a period of 1 month from the filing of the application. Prompt release proceedings are also independent, not incidental proceedings, and the decision of the tribunal takes the form of a judgment. In its judgment, if the tribunal decides that the allegation of the flag state is well-founded, the tribunal will determine the amount, nature, and form of the bond or financial security to be posted for the release of the vessel and its crew. Once the bond or other financial security determined by the tribunal in its judgment has been posted, the authorities of the detaining state are required under the Convention to comply promptly with the decision of the tribunal. The procedure under Article 292 has served as an efficient tool to obtain the release of vessels and crews in a number of cases. Since in its inception, 10 applications for the release of vessels and crews have been made to the tribunal in accordance with that provision. Now, a fundamental aspect in prompt release cases has been to assess the reasonableness of the bond, bearing in mind that the Convention does not define this term. In the Camuco case, the tribunal identified factors to assess the reasonableness of the bond. According to the tribunal, these factors include the gravity of the alleged offense, the penalties imposed or imposable under the laws of the detaining state, the value of the detained vessel and of its cargo, the amount of bond imposed by the detaining state, and its form. In that case, in the Camuco case, a French court had ordered the release of the fishing vessel Camuco, flying the flag of Panama, which had been accused of illegal fishing, subject to a payment of the bond in the amount of 20 million French francs at the time. In its judgment, the tribunal considered this bond not to be reasonable and set a lower bond at 8 million French francs in the form of a bank guarantee or if agreed to by the parties in any other form. The tribunal ordered the release of the vessel and the master upon the posting of the bond. The tribunal has applied these factors in subsequent cases and added some clarifications. For instance, in the Monteconfurco case, it observes that this is by no means a complete list of factors and that the tribunal did not intend to lay down rigid rules as to the exact weight to be attached to each of them. In the Volga case, faced with the issue of non-financial conditions of the security required for the release of the vessel, namely that the vessel be equipped with a vessel monitoring system, the tribunal determined that such non-financial conditions cannot be considered components of a bond or other financial security for the purpose of applying Article 292. Each of the applications for prompt release the tribunal has received so far have been made on the basis of Article 73, paragraph 2 of the Convention for violation of fishing laws in the exclusive economic zone. I should be add in parentheses that there was an application made in 2022, which was based on a non-restrictive interpretation of Article 292, but this application was withdrawn a couple of days after the filing of the application. No application for prompt release has been made, however, on the basis of a marine pollution offense. I will turn now to the procedure for the prescription of provisional measures under Article 290 of the Convention and will focus on cases before the tribunal in which the applicant requested the release of a vessel and its crew as a provisional measure. A number of such requests have been made when a vessel had been detained for reasons other than those allowing for the application of a prompt release procedure under Article 292. In 4 provisional measures cases, the tribunal prescribed provisional measures concerning the release of a vessel and its crew. As pointed out by a commentator, it seems that provisional measures were used as an alternative to the prompt release procedure. Article 290 provides in its paragraphs 1 and 5 for 2 different situations. As provisional measures are inherent to the judicial function, under paragraph 1, a party to a dispute before the tribunal may request it to prescribe provisional measures, and such request may be made at any time during the course of the proceedings. Provisional measures under paragraph 1 are treated as incidental proceedings. Under paragraph 5, however, the tribunal is competent to deal with a request for the prescription of provisional measures when the merits of the case have been submitted to an Annex 7 arbitral tribunal by virtue of the choice of procedure made under Article 287 of the Convention. Since the constitution of the arbitral panel would take some time, failing agreement by the parties within 2 weeks on any court or tribunal, the Convention has given ITLOS compulsory jurisdiction to prescribe provisional measures in the interim period, pending the constitution of an arbitral tribunal. For ITLOS to exercise this jurisdiction, the dispute must first be submitted to an Annex 7 arbitral tribunal, and the request for provisional measures must be included in the arbitral notification. After 2 weeks, the request for provisional measures may be submitted to ITLOS. However, if the parties so agreed, the request may be submitted to the tribunal at any time. A request under Article 290, paragraph 5 of the Convention is treated as self-contained procedures. The procedure for provisional measures is also an urgent procedure and is very similar to that of prompt release. However, there is no fixed time limit for the holding of a hearing or for the submission of a written response by the respondent state. In addition, the decision of the tribunal in provisional measures is in the form of an order. In the tribunal's practice, this order is issued within a period of 4 to 8 months from the filing of the request. The order is binding, for which the parties are required under the Convention to comply promptly with any provisional measures prescribed. The tribunal may also follow up on the measures prescribed by requesting the parties to submit reports on compliance. Subject to an application for prompt release, a request for provisional measures has priority over all other proceedings before the tribunal. Now, for the tribunal to prescribe provisional measures, a number of conditions must be met. First, the tribunal may only entertain a request for provisional measures if the tribunal, when acting under paragraph 1, or the arbitral tribunal, when acting under paragraph 5, would have prima facie jurisdiction to deal with the merits of the dispute. In this regard, the approach followed by ITLOS has been to examine whether the provisions of the Convention invoked by the applicant appeared prima facie to afford a basis on which the jurisdiction of the tribunal or the arbitral tribunal, as the case may be, might be founded. At this point, the tribunal would also deal prima facie with objections to jurisdiction. Provisional measures consist of interim measures of protection, and under Article 290, its specific purpose is to preserve the respective rights of the parties to the dispute or to prevent serious harm to the marine environment pending the final decision. This applies to both proceedings under paragraph 1 and paragraph 5. A requirement of urgency is therefore to be met for the tribunal to prescribe provisional measures. Urgency means that the tribunal has to determine whether there is a real and imminent risk that irreparable prejudice may be caused to the right of the parties or serious harm to the marine environment before the final decision on the merits is delivered. However, there is a slight nuance in the provisional measures under paragraph 5, since this paragraph specifically refers to the urgency of the situation. This implies that the temporal context of urgency under paragraph 5 is different to that under paragraph 1. The tribunal has therefore assessed the urgency of the situation under paragraph 5 in the context of the period until the Annex 7 arbitral tribunal would be constituted or operational. In addition, in recent jurisprudence, the tribunal has applied the plausibility of rights standard and has therefore examined whether the rights which the applicant seeks to protect are plausible. In a recent provisional measures case, the tribunal stated that it was not called upon to settle the competing claims of the parties and that at this stage of the proceeding, it was not called upon to determine definitively whether the rights claimed by the applicant exist, but need only decide whether such rights are plausible. I would like now to briefly illustrate how provisional measures proceedings have served to seek the release of a vessel. The first instance in which the tribunal ordered the release of a vessel as a provisional measure was the case of the Ara Libertad, an Argentinian warship frigate detained by the Ghanaian authorities at the port of Tema. According to Argentina, the vessel was on an official visit to Ghana, and with a view to obtaining the release of this warship, Argentina requested the tribunal to prescribe provisional measures under Article 290, paragraph 5 of the Convention. The tribunal delivered its order in December 2012. I would like to make two remarks in respect of this case. First, in its order, the tribunal established the prima facie jurisdiction of the Annex 7 arbitral tribunal to which the merits of the dispute had been submitted on the basis of only one of the provisions invoked by Argentina, namely Article 32 relating to the immunities of warships. After noting that Article 32 does not specify the geographical scope of its application, the tribunal considered that a difference of opinions existed between the parties concerning the applicability of this provision, and therefore a dispute appeared to exist concerning the interpretation or application of the Convention. Second, the tribunal found that the urgency requirement was met after addressing a number of legal and factual considerations, namely that a warship is an expression of sovereignty of the state whose flag it flies, and in accordance with general international law, a warship enjoys immunity, including in internal waters. That any act which prevents by force a warship from discharging its mission and duties is a source of conflict that may endanger friendly relations among states, and that there had been attempts by the Ghanaian authorities to board the warship and to move it by force to another berth, which demonstrated the gravity of the situation since then. Thus, the tribunal found that the urgency of the situation required the prescription of provisional measures that will ensure full compliance with the applicable rules of international law, thus preserving the rights of the parties, and order as a provisional measure the release of the Ara Libertad, its commander and crew, as requested by Argentina. In light of the time, I was about to explain a bit the urgency in the MT San Padre Prio, but I believe Judge Lynsat covered this case. The urgency was, of course, an important element in this case, the San Padre Pio, a provisional measures case, which I chose also to present here because, as you can see from the slide, this is the operative provision A. In this case, I think Judge Lynsat focused more on B and C. I wanted to focus on A because here the tribunal agreed to, or decided to order the prescription of a provisional measure ordering the release of the MT San Padre Pio, but upon the posting of a bond in the amount of $14 million to be posted with Nigeria in the form of a bank guarantee. And I wanted to discuss this case because, in that sense, it's different from the Ara Libertad, where no bond was ordered. So this kind of provisional measure, I refer here to the MT San Padre Pio, namely prescribing the release of a vessel upon the posting of a bond, has some similarities to prompt release procedures. To conclude, the case law of the tribunal demonstrates that prescription of provisional measures offers another means alongside prompt release proceedings for securing the release of a vessel and crew. And this brings me to the end of my presentation. I thank you very much for your kind attention.
Thank you. Thank you, Hamana, for this interesting presentation. And so these procedural mechanisms ensure swift and fair process for handling vessel detention and addressing disputes, ultimately supporting the goals of UNCLOS framework. Thank you very much. If you have any questions, please, our panelists are waiting for them. Yes, yes, from the back, please.
Hi. Thank you for your address. I'm Kunal Gaikwad. I'm from India, and I'm currently studying in IMLI. So my question is on Article 292.2. It states that by and on behalf of flag state. Now I understand, but that by the flag state, it's pretty clear that it's between the states, and the states only can approach the ITLOS fora. But how about on behalf of flag state when it comes to, especially for the release factor and the interim measure factor? On behalf of the flag state, can these words be used for, let's say, I'm the ship owner and my vessel has been arrested. I have been given the power by my government or some sort of an authorization that you can go to ITLOS and seek for an arrest. And in the meantime, we can try and consider whether we can make any representation before ITLOS or not. Thank you.
Thank you for that question. Well, it is a formulation that you notice, by or on behalf of. So by the flag state, I think that is nothing new. Your ship is arrested, flag state wants to take action. Has made its decision, we want to take action. And the flag state does not have to prove that it has the authority to do so because it's in the Constitution. Maybe it needs to prove that at that particular point in time, it was truly the flag state. And so if the ship has run out of the registration, it can no longer be represented by the flag state or the formal flag state. Now, the on behalf of is the, let's say, the specific bit about representation in the situation of prompt release. And it does mean, as you suggested, that certain others may represent the ship if they have obtained the authority from the flag state of the ship to represent that ship. So the flag state itself is not representing the ship, but someone shows up, like a lawyer, a barrister, and provides the right type of document which will be enough for the tribunal to accept that the flag state has mandated this person as the representative, basically between brackets of the flag state, be the representative of that ship. So it's like they've received a proxy. And I think that that part of the sentence is there to speed up things in a prompt release case, and also to, in a way, broaden the possibility of access to those cases. Because basically, as I said in my part of the presentation, whether or not the flag state takes action when a ship owner comes around and says, help, help, my ship is in trouble, you are the flag state, do something. It's a question of discretion. And by having this type of rule in Article 292, paragraph 2, there is a window to represent the ship, provided you raise the right question with the flag state. So you're no longer asking the flag state, can you please, please, please do it? You're just asking the flag state, could you give us a written authority to represent the ship, technically speaking, on your behalf? Yeah?
Yeah, just to add that in the rules of the tribunal, the procedural rules, this is further elaborated at what type of authorization, We have also a guide, kind of a brochure. We left some flyers there with the QR code. So it's through that QR code you can access our guide to proceedings. And there we have some model forms, for instance, how to draft an authorization to authorize a lawyer or a ship owner to bring a prompt release to the tribunal. The proceedings at the end continue being interstate proceedings, and in a number of the prompt release cases already dealt with by the tribunal, there were in fact a private lawyer behind the case that obtained the authorization by the Ministry for Foreign Affairs or the Attorney General of the country, of the flag state of the vessel.
Thank you very much, Judge and Dr. Hinrichs, for those excellent presentations. I have a comment and a question for the judge. The comment is that one of the very interesting things that this committee is dealing with at the moment is the implications of autonomous vessels, and particularly where you have remote control centres in third countries. And it occurs to me that the challenges that you identify around a flag state no longer having control over members of the crew puts a lot of pressure on that state and their ability to satisfy their obligations potentially. So that's just a comment, I think, for this committee to dwell upon. My question is around dispute resolution. And in the case of a flag state wanting to exercise protection over its crew, in most cases it would be the only one to have standing before a court or tribunal to take action under UNCLOS. But it occurs to me that Article 288 of UNCLOS, and particularly the incidental jurisdiction of courts and tribunals, is getting a lot more attention these days. I think of the Enrique Lixi case. Obviously, I don't want to ask you to prejudge anything, but I wonder what your thoughts would be on the possibility of a diplomatic protection claim being entered as a matter of incidental jurisdiction of a court or tribunal under Article 288.
I'm not sure if I fully understood your question. In a situation where the flag state is intending to take action, obviously the flag state gets a list of whoever is on board. And state A that has nationals on board probably will have addressed the flag state, particularly in, let's say, very visible cases, cases that are reported on the television, etc. And this is why I refer to NGOs, because with NGOs, not every, but many members of NGOs will start calling the minister. Greenpeace ship is arrested, do something. Now, what I tried to say is that if we read what the International Law Commission has said, they want to keep these two issues apart. On the one hand side, there is diplomatic protection for the flag state. Traditionally, originally, that used to be protection for the vessel only, and maybe your own. There was a time when the crew was had the same nationality as the ship, but that is a while ago. And at the same time, also, the diplomatic protection by the national state of the individual crew members, they go alongside. That is essentially the starting point for the ILC. Through the way they describe this, I said it's really inverse or anything, something like that. It's sort of showing both sides of the coin. They are literally saying, well, these exist alongside, but that does not stop the flag state from extending its protective scope. That on the one hand side, it would be on the basis of diplomatic protection for the ship, and on the other side, it would be the ship as a unit rule, without further qualifying what exactly the legal status of that rule is. That's why I mentioned, well, in such a case where both sides, you know, on the side of the crew might be a number of interested states, it's becoming a large party. So my suggestion, non-legal suggestion, but from my days as a diplomat, I would say get together, sort out how you want to do this. If you are looking at possibilities of intervention, that really goes quite a step further, because with intervention, apart from that being a procedural step where the other side could also make comments, or we will accept the intervention or we won't accept the intervention because whatever, but it means not only that as an intervening state, if you are admitted, you will also be responsible for the final decision, including whatever decision there would be possibly about state responsibility. But you might, and so you might be in for more than you want to. If your aim is to see that your own nationals are properly protected, I would suggest you go and talk to the flag state and just get a sense of what it is that they aim to do, without saying, well, we jump in because you'll be in the whole case. It's when it is about, so things like the more human rights aspect of what are you doing with my crew who have now been detained in faraway land for 6 weeks and they haven't had the possibility to call home, things like that. So if you trust that the flag state sees all of these issues, you might as well have some consultations as the case moves on, but you may not want to be fully engaged. Sort of a halfway response, I guess. Maybe the registrar wants to add. No, okay.
Thank you. Are there any other questions? I see none. We will give a short break, like 15 minutes, so we change the panelist. And then we will get back again, please, here by 4 o'clock. Yes, thank you.
Insomma, mi sparavano il speciale.
So, ladies and gentlemen, welcome back. So if you'd like to take your seats, we'd like to turn to the second part of our panel discussion. Thank you. And I wish to give the floor now to our second moderator, Professor Judge at ITLOS, Mr. David Attard, please.
Thank you very much. Distinguished guests, members of the IMLI family, it is my honor and privilege to moderate this panel composed of eminent lawyers on a subject which deals with the essentials of flex day jurisdiction. Some problems that we will be tackling here have been long-standing. I recall we had a similar meeting like this one about 5 years ago, and the meeting and the problems still face the international community, and there are new challenges which I'm delighted will also be dealt by this excellent panel of international lawyers which we have this afternoon. On a personal note, before I introduce the first personality, I wish to say that I am conscious of the fact that, except for me, all the panel speakers were women, which is extremely positive, but also because it reminded me when in 1988 we were negotiating the IMLI statute with Srivastava, Secretary General Srivastava. It was proposed that there would be a clause in the statute to reserve 50% of the places for deserving women candidates from developing countries. It was the first time that that was inserted in a UN statute, and I'm pleased to see the fruits of that initiative, which was to the merit of the Secretary General. I wish now to invite Professor Judge Caracciolo, who is going to address us on nationality and registration of ships. Judge Caracciolo has been a judge since 2020. She is a full professor of international law. She is a member of the Permanent Court of Arbitration and has been a legal advisor to the Foreign Ministry. She's been ad hoc judge on a number of courts, and she has written extensively on the subject. I'm really delighted that she will address us on this very important subject. Judge Caracciolo, please.
Thank you, Mr. Chair. It's my delight to be here, and I wish to thank, first of all, IMO and the Cyprus government for hosting this workshop. As Judge Attard has just told you, the topic I was assigned is nationality and registration of ships, and therefore to that end I will pass through the following issues very rapidly for you, given it is a Friday afternoon and the weekend is approaching rapidly. First, I will address the evolution of nationality of ships, Article 91 of ITLOS, which is a unique relevant provision in this context of nationality and registration. And then I will conclude by referring to some limitations which are determined at the international law level concerning the liberty of states to grant their nationality to vessels. So, concerning the role, the evolution of nationality of ships, the idea of granting nationality to vessels was originally conceived in the early 18th century to protect vessels during their navigation through high seas, which at that time were mostly unregulated, to protect them from dangers such as piracy or the capture from other states. This idea evolved during the 18th and 19th century, and in particular at the end, the second half of the 19th century, states started to adopt domestic legislations on registration. The first registries of ship dated that time, and also states started to conclude bilateral treaties, the very well-known treaties on commerce and navigation, which dealt with registration. In general terms, states were already more or less free to determine the conditions for conferring upon vessels their nationality. This trend was confirmed by the 1958 Geneva Convention on the High Seas, and in particular in its Article 5. During the third UN conference on the law of the sea, the issue of nationality was a minor one. And this is probably the reason why Article 91 is fully identical, is more or less identical to Article 5. The only main difference is given by the fact that the reference to jurisdiction and control by the flag state in technical, administrative, and social matters was dropped in Article 91, since these aspects were spelled out in a more detailed manner in a new article, Article 94 of ITLOS. And concerning Article 91, which is, as I already told you, the core provision in the law of the sea concerning nationality and registration, it is a rather complex, articulated norm consisting of two paragraphs, and in particular, paragraph 1 is particularly intricated. It opens with the sentence that ships have the nationality of the state whose flag they are entitled to fly. However, Article 91 doesn't tell us what nationality means. And we don't have any case law at the international level explaining us the meaning of nationality. So we need to refer to scholars, and in particular, I always like to refer to a former judge and still a professor former judge in ITLOS and still a professor, Wolfram. He explained very clearly that nationality of ship is a completely different concept from individuals' nationality. It also emphasized that it is not a subcategory, so a larger category, nationality, and a subcategory, nationality of ships. Since nationality of ships plays a specific role, and in particular three roles. It indicates which state is permitted under international law to exercise jurisdiction and control over a vessel, which state is obliged to implement the duties listed in Article 94 of the ITLOS, and to enforce domestic and international legislation on labor, safety of navigation, security of navigation, and environmental protection. And finally, as Judge Linzard has just explained to us, which vessel, which state is entitled to render diplomatic protection for the vessel and the crew. O'Connell, another very famous scholar in the law of the sea, briefly observed that in short, that nationality is a shorthand for saying that a ship is jurisdictionally connected with a state. Article 91, paragraph 1, establishes also that a state must fix the conditions for the grant of its nationality to ships. Here, in this part, Article 91, paragraph 1, codifies a very long-lasting general rule of international law. Indeed, already in the early years of the 20th century, the Permanent Court of Arbitration, in a famous case, Muscat-Dawes arbitration, France versus Great Britain, recognized the existence of these general rule according to which every sovereign decides to whom he will accord the right to fly his flag. And also domestic courts and tribunal confirmed this approach, as it is highlighted by a US Supreme Court decision in Lauritsen versus Larsen. But apart from these decisions, which date back in time, it is to the ITLOS, the jurisprudence we have to refer, since ITLOS has extensively interpreted Article 91 in connection also with Article 94. ITLOS analyzed these articles in two cases already mentioned before, Saiga number 2 case and the Virginia G case. And the tribunal emphasized, highlighted the fact that each state enjoys exclusive jurisdiction over the granting of its nationality to a vessel, and also ruled that Article 91 codifies a general rule of international law. And this conclusion was confirmed in the Virginia G case. Concerning the modalities for the granting of nationality to ships, of course, being a matter of domestic jurisdiction, UNCLOS doesn't contemplate specific means through which a ship might gain a state nationality. We have, however, a very well-established state practice, which shows us that usually states in their respective domestic legislation utilize the means of registration of ships, especially mainly for merchant vessels. More rarely, they refer to registration for ships utilized for internal navigation, for warships, or for small size ships, like, I don't know, sailing boats or small yachts, just to give you an example. And ITLOS, by its turn, recognized this practice, again in SAIGA number 2 case, where it passed through these various means and confirmed that the choice of means is a matter of domestic jurisdiction, of the exclusive jurisdiction of the flag state. What, on the contrary, UNCLOS does is to impose to states, to flag states, to issue documents demonstrating the nationality they have conferred upon a ship. And this is indicated in Article 91, paragraph 2, The tribunal, in two cases, SAIGA, number 2 again, and Grand Prince, mentioned some of these documents, which are named in with different terms in states' practice. For example, certificate of navigation, patent of navigation, certificate of number of a ship. And the tribunal ruled that the nationality of a ship is a question of fact to be determined on the basis of evidence adduced by the parties. And it also noted that the conduct of a flag state at all times material to the dispute is important in determining the nationality or registration of a ship in case a dispute is submitted on that issue to the tribunal. We have also another article which highlights the importance of documentation, which is Article 94, paragraph 2a, which imposes upon states the duty to maintain national registries of ships. And then I will dwell with the most ambiguous sentence in Article 91, paragraph 1, namely that there must exist a genuine link between the state and the ship. Well, the reference to a genuine link was a sort of mediation with reference to Article 5 of the 1958 Convention, Geneva Convention on the High Seas, between two opposing positions. On the one side, the position of those states and scholars which considered that some conditions or all conditions for the granting of nationality to ships should be defined at the international law level. And on the contrary, those states and scholars which maintained that states were at liberty to decide within their respective domestic systems orders when and how to confer upon vessels their respective nationality. Some proposals on the first approach were during the time submitted. The most important one is the proposal from the Institut du Droit International at the end of the 19th century, which was fully followed by the International Law Commission in its first draft concerning this issue, the draft of 1955. The rapporteur, the special rapporteur, François, followed this approach and produced a very complex rule, which, let's say, revolved around nationality of the flag state by the owners or individuals or legal entities. During this first proposal was changed under the pressure of some European states, led by the Netherlands, which proposed to eliminate all this complexity and to speak more generally about a genuine link. And but in this proposal, the genuine link was connected with the possibility for other states not to recognize the nationality in case of absence of such a genuine link. During the conference, which at last led to the adoption of Article 5 and the entire Geneva Convention on the High Seas, this second part was dropped. So just the reference to a genuine link remained in the article. And this was in between the Geneva Convention and the entry into force of the ITLOS. Nothing relevant happened in this field. We can think about a separate opinion of Judge Jessup, but it's a separate opinion. And we can refer to the 1986 UN Convention on conditions for registration of ships, which is based, provides for ownership as a condition for the granting of nationality to vessels. This convention, as you know, has not yet entered into force. And, what about Article 91, paragraph 1? It has been extensively interpreted with reference to the sentence A, genuine link, by ITLOS in the SAIGA number 2 case. In its judgment, the tribunal ruled that Article 91, paragraph 1 doesn't answer to the question whether, in case of absence of a genuine link, the other states are allowed to contest, not to recognize the nationality of a vessel. Nor answers come from Article 92 and 94. And in achieving this conclusion, the tribunal took into consideration the negotiating history of Article 5 and then of Article 91, which is more or less a copy of Article 5. So the conclusion of the tribunal has been that the reference to a genuine link means to secure a more effective implementation of the duties of the flag state and not to establish criteria by reference to which the validity of the registration of ships in a flag state may be challenged by other states. And the conclusions of the tribunal were supported by the tribunal itself by reference to the 1995 agreement on fish stocks and highly straddling fish stocks and highly migratory species fish stocks, and the so-called 1993 compliance agreement, which imposes to flag states of fishing boats several obligations, but not the obligation of ownership for granting their flag. And in the Virginia case, the tribunal even more clearly ruled that the reference to a genuine link should not be read as establishing prerequisites or conditions to be satisfied in the exercise of the right of the flag state to grant its nationality to ships, but again, this reference is connected with Article 94 of the Convention, so to the duty to exercise effective jurisdiction and control. And moreover, in case when a state doesn't, if the flag state doesn't exercise such effective jurisdiction and control, what can be done by other states? They can investigate, it is established by Article 94, they can investigate and then they can refer the results of their investigation to the flag state, which, as appropriate, may take any action necessary to that end. And I will now conclude by mentioning some limitations to the granting of nationality to ships, which, however, are established by international law. The first category of limitations can be provided for in bilateral or multilateral treaties, which may prohibit to grant nationality under certain circumstances. For example, think about the 1993 compliance agreement, for example. And a second category of limitations is established directly by the ITLOS in Article 92, paragraph 1. States are not allowed to grant their nationality to ships already having a nationality. And safe during a voyage, safe in case of a real transfer of ownership or change of registry. The consequences stemming from such double nationality are rather serious, since the ship must be considered without nationality and therefore submitted to the jurisdiction of every state party to the convention. And think I will just rapidly refer to a very famous activities on the high seas that state can carry on, the right to visit. Well, the right to visit in Article 110 is all around ascertaining the nationality of the ship in order to, for the captor, the boarding state, the visiting state, to determine if the vessel has its nationality or the nationality it's presenting is a real one. So you see, everything is linked in a rather harmonious system of norms in the ITLOS. And now I will stop and thank you for your attention.
Thank you very much, Judge Caracciolo, for a very comprehensive review of the regime of nationality in a relatively short period, but you have covered the important points. I recall many years ago, pre-ITLOS, the lawyer you referred to, Daniel Patrick O'Connell, used to refer to genuine link as chasing the chimera. But this was pre-ITLOS. And as you rightly point out, ITLOS has clarified the genuine link considerably. It is now my great pleasure to introduce Dr. Dorota Loseminska, who is probably best known of the panelists in this room, but nonetheless, there are others who are not members of the legal committee here, and I would like to say she is the Director of the Legal Affairs and External Relations Division of the IMO, where she leads the activities of the division on various complex and topical subjects of international maritime law and treaty law. Before joining IMO, she was the head of the Polish delegation to the IMO Legal Committee and delegate to a number of IMO meetings, and in particular, she served as vice president of the HNS Diplomatic Conference. Dr. Loseminska has a Master's of Law and a PhD, but she also has a Master's of Law from IMLI, and to us she represents one of the shining examples of the IMLI tradition. Dr. Dorota.
Thank you very much, Professor Attard. Good afternoon, delegates and guests. Thank you very much for bearing with us after a very, very long and busy week. Even though the weather outside looks nice, you still decided to bear with us during this very, very good event that we organized together with our friends from ITLOS. Of course, the subject of fraudulent registration and registries of ships is very familiar to all of you, to all present in this room. So my presentation will be more to recap what has happened over the past years at IMO. We've heard very good presentations, very good explanation about what nationality of a ship is. Unfortunately, we do not live in an ideal world, and there are some ships that are fraudulently registered and fly fake flags. Of course, those ships do not have nationality and do not have the protection that is connected to the nationality. So let me go back in time and explain what has happened here at IMO, in particular at the legal committee over the past decade. As we know, the measures to prevent unlawful practices associated with the fraudulent registration and fraudulent registries of ships is one of the outputs that is on the strategic plan of the organization. The subject has been brought to the attention of the organization exactly 10 years ago. So for the past decade, we are dealing with it, and we are taking step-by-step measures to tackle, to address the subject. The first time that we've heard about a fraudulent registry was brought to our attention in July 2015 by the government of the Federated States of Micronesia. That there were several dozens of ships flying the flag of Micronesia. Micronesia obviously does not operate a registry. The state is not an IMO member, and of course all those activities were absolutely illicit and criminal. Then the problem was officially brought by the Democratic Republic of the Congo to the legal committee. The Democratic Republic of Congo submitted a document to the legal committee bringing to your attention the fact that there were again several dozens of ships registered under the DRC flag, which simply did not exist. The DRC did not operate a registry. And that was alarming, and therefore a group of states, we can see that the proposal was co-sponsored by Cyprus, DRC, Fiji, Germany, Morocco, Spain, and Vanuatu, submitted a proposal to the 105th session of the committee to address fraudulent registries. And since then, the Secretariat started reporting on the cases and bringing more awareness to the global maritime community about this sad phenomenon. The discussion at leg 105 and 106 resulted in bringing the matter to the attention of the IMO Assembly, and in 2019 and at the 31st session the Assembly adopted the first resolution to address the fraudulent registration, and the resolution was aiming at prevention of the fraudulent registration. It includes a procedure for communicating information on ship registries to IMO, including the information on the name of national government body and authorized bodies or delegated entities in charge of ship registration. And this is also when we created module on GISIS, and we started reporting also on this on the GISIS module. The legal committee continued tackling the issue, addressing the issue, and formulated several definitions that are helping to understand what we are talking about. So when we talk about fraudulent registration, this means the unauthorized use of a country's flag, and it can be in various forms. We have cases in which the flag and the registration is completely fake. We have also cases in which in the past a country might have authorized an entity, a company, to indeed run or operate the registry for them, but then this country withdrew or discontinued the contract with such a company, but the company, despite that, continued to operate and registered ships, which of course is also an unauthorized and illicit use of flag. And on the GISIS module, we created a separate category of false flags, and you can now see those ships which are identified as flying a false flag on GISIS. So this is the under the ship and company particulars, and either by a flag state or by IMO number, you can see which which ships have false flags. Again, the matter was brought to the attention of the Assembly in 2021, and the Assembly adopted another resolution on the encouragement of member states and all relevant stakeholders to promote actions for the prevention and the suppression of fraudulent registration and fraudulent registries of ships and other fraudulent acts in the maritime sector, because of course we are not talking only about fraudulent registration and fraudulent registries, but as you are well aware, we also have fraudulent certificates of competence, illicit activities regarding the engagement of crew, and various other illicit activities. So we are trying to tackle them as well at the legal committee. The legal committee commissioned a study to address issues arising in connection with fraudulent registration, and this study was carried out by WMU, UNCTAD and IMLI, and it looked at various questions related to this phenomenon, such as what are the practices, what types of fraudulent registration exist, what are the adverse impacts of fraudulent registration, what are the conventions and treaties related to the issue, and whether this issue would be considered as a crime or as an offense. Is it national, regional, or international in its nature? So this study was then considered at the previous session of the legal committee, well, now the legal committee 111, and as a result of inter alia, as a result of this study, the committee decided to continue addressing the issue and re-established a correspondence group on due diligence and IMO identification number scheme, and tasked the group with defining and develop the elements of due diligence in the process of ship registration, and develop a proposal for a new output. This proposal was brought to this session of the legal committee, and 10 years after it was initiated, now the proposal was
accepted by the legal committee, and the legal committee decided to put on its agenda for the next session, like 113, a new output to develop guidelines or best practices on the registration of ships. There is also another interesting output that was decided by this legal committee to conduct regulatory scoping exercise to identify provisions which could strengthen the control or the addressing substandard shipping. So we will be looking at those issues for the next couple of sessions. At least 2 sessions will be dedicated to discussing the measures that the organization can take in addressing fraudulent registries, but also in addressing broader issue of substandard operations and substandard shipping. And I very much look forward to those discussions next year at the legal committee, and I am sure that you will all work very hard intersessionally to produce very, very comprehensive and good documents to the next session. Thank you very much.
Thank you very much, Dorota. It is indeed a relief to hear of the active work that is being done to combat this dangerous process development, because it undermines the very foundations of the maritime order. You cannot have fraudulent registries allowed to prosper, as it undermines the flag state jurisdiction regime, and therefore it is quite a pleasure to read and to hear you describe the activities of the legal committee in this field. I thank you once again. I now address Mrs. Lydia Malkari. First of all, let me congratulate you on being elected Vice President of the Legal Committee. She is the head of the Legal Affairs Unit of the Shipping Deputy Ministry of the Republic of Cyprus. She has served in the Cyprus Maritime Administration as legal officer for more than 20 years and has extensive experience in drafting of legislation and its implementation. She has been particularly focused on the implementation of IMO conventions and those related to the law of the sea. On this note, I invite Lydia to address us on due diligence in ship registration, a member state's perspective. Of course, this is the legal formula which is very much in use throughout the convention.
Thank you so much, Judge Attard, for the introduction. Good afternoon, Your Excellencies, distinguished delegates. It is very challenging to come last after such distinguished speakers and interesting presentations. Equally challenging and continuously evolving is the matter at hand. I will be presenting to you this afternoon the Cyprus Flag Administration's perspective on due diligence in ship registration. Due diligence plays an increasingly important role in international law and the law of the sea. In terms of dictionary definitions, due diligence has been defined as the degree of care that is to be reasonably expected or that is legally required, and assessing and evaluating conducted with prudent, unnecessary care, the care that the reasonable person exercises to avoid harm to other persons or their property. In the Corfu Channel judgment, the International Court of Justice, in defining the due diligence principle, ruled that it is every state's obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. According to the International Tribunal for the Law of the Sea Advisory Opinion of 21st May 2024, on the request of the Commission of Small Island States on Climate Change and International Law, the obligation of due diligence requires a state to put in place a national system, including legislation, administrative procedures, and an enforcement mechanism necessary to regulate the activities in question and to exercise adequate vigilance to make such a system function efficiently with a view to achieving the intended objective. The standard of this obligation is determined by, among other factors, an assessment of the risk and the level of harm combined. In presenting due diligence in ship registration in the Cyprus Register of Ships, the following will be addressed. In part one of this presentation, I will provide an overview of the Cyprus National Legal Framework on Ship Registration, and in the second part, key features of due diligence established practices and checks will be identified. The Register of Cyprus Ships was initially established in 1963, and it is governed by the Merchant Shipping Registration of Ships, Sales and Mortgages Laws of 1963 to 2020. The Register of Cyprus Ships, in essence, exists for the fulfillment by the Republic of Cyprus of its conventional obligations arising under the 1982 United Nations Convention on the Law of the Sea, UNCLOS Articles 91, 92, and 94. Our national legislation is comprised of around 350 pieces of legislation which implement international conventions to which Cyprus is a party, including IMO, instruments on safety, security, liability, and pollution prevention, and ILO instruments. Being an EU member state, the Cyprus Registry also applies the EU acquis on maritime transport. In addition, the provisions of the government policy on the registration of ships under the Cyprus flag apply. We have 4 types of ship registration: provisional, permanent, parallel in, bareboat chartered in registration, and parallel out, bareboat chartered out registration. Turning now to the conditions of ownership and who can own a Cyprus ship. Citizens of the EU, of the European Union, European Economic Area, and registered legal entities of the EU EEA, as well as non-EU, non-EEA registered legal entities controlled by EU citizens. If the owner of the ship is not a Cyprus national or a company incorporated in the Republic of Cyprus, it is required to appoint and maintain an authorized representative in the Republic of Cyprus, or to ensure that the management of the vessel is entrusted in full to a Cypriot EU EEA ship management company having its place of business in Cyprus. Who can register a Cyprus ship? Under the advocates' laws of Cyprus, only lawyers registered as practicing advocates in Cyprus are entitled to carry out ship registry transactions, which includes ship registration, transfers of ownership, registrations, transfers, and discharges of mortgages, change of ship's name and alteration of ship particulars, and deletion of ships. Therefore, all registry transactions must be carried out through a local registered advocate. I'd like to refer to some powers that the Shipping Deputy Minister has under our ship registration laws. Under Section 14A, the Shipping Deputy Minister may give directions for the non-registration of ships if it would be contrary to the general policy followed by the government or to the public interest in general. Moreover, under Section 6A of our ship registration law, the Shipping Deputy Minister has the power to revoke the Cyprus character of a ship if it repeatedly violates laws or international treaties or engages in operations against the public interest, and this includes issues relating to seaworthiness, crew conditions, or licensing of the ship. In addition, if you can go to the next slide, thank you. Under Section 72 of our ship registration law, the forgery or fraudulent alteration of registration documents is a criminal offense punishable by imprisonment and/or a fine upon conviction. And under Section 73 of our law, the submission of false declarations to the registrar or production of documents in relation to the registration of a vessel is also a criminal offense. Proceeding now to the second part of our presentation, in addition to the obligations that our ship registry performs on a 24/7 basis in order to have a high-quality fleet and to ensure implementation of its obligations pertaining to safety, security, environmental protection, liability, and protection of seafarers' rights, due diligence is performed for all registry transactions in order to establish ownership and vessel identification, ensure that fraudulent registration or abuse of the Cyprus flag do not take place, and safeguard compliance with economic trade sanctions. The Shipping Deputy Ministry has an ISO quality control system covering all operational activities of flag state. From the point of view of ship registration, we have 3 procedures in place. The first one describes the actions taken for a vessel to be registered in the Register of Cyprus ships. The second ISO procedure describes the actions taken for a deletion of a ship. And the third one governs the procedure for the issuing or renewal of civil liability certificates. So these are the CLC, Bankers, Wreck Removal, Athens, PLR certificates. Registry transactions are only performed by the Registrar of Cyprus ships and assistant registrars, who are all officers, scientific staff, mainly maritime affairs officers with a legal background and marine surveyors of the Shipping Deputy Ministry. The complete list of authorized assistant registrars of Cyprus ships, their names and their positions, is published on our website for transparency, fraud prevention purposes. At the office, registry transactions are only performed at the offices of the SDM in Cyprus and abroad. We maintain 6 offices abroad in Athens, Brussels, London, Hamburg, New York, and Rotterdam, which are all staffed by competent officers, scientific staff of the Shipping Deputy Ministry. Turning now shortly to other relevant national legislation of a more horizontal nature, pursuant to the Prevention and Suppression of Money Laundering Activities laws, the Cyprus Bar Association constitutes a supervisory authority. Under these laws and the directives issued by the Cyprus Bar Association to its members, client identification procedures and due diligence obligations derive. Pursuant to a national law on the implementation of UN Security Council sanctions and EU restrictive measures, all national competent authorities, including the Shipping Deputy Ministry, and all supervisory authorities, such as the Cyprus Bar Association and the Institute of Certified Public Accountants of Cyprus, have a duty to implement the UN-EU sanctions. In order to promote compliance of the Cyprus shipping industry, we issue sanctions information notices addressed to the ships flying the Cyprus flag, and all these notices are available on our website. In addition to the due diligence checks performed at the lawyer's level, through whom, as we mentioned before, all registry transactions are performed, the following constitute key features of the checks performed by the registrar of Cyprus ships exclusively by officers with a legal background. Pertaining to ownership, a thorough review of documents, including, in case of legal entities, certificates of incorporation, directors and shareholders' certificates and passports, as well as bills of sale and previous registry documents, and IMO unique company and registered owner identification number checks to ascertain ownership, and ensuring that the vessel is not owned by a natural or legal person subject to sanctions. Turning now to due diligence on vessels, high standard criteria set out in the government policy on ship registration are applied, such as criteria pertaining to vessels' age and safety record. The Cyprus flag is consistently placed on the white lists of Paris and Tokyo MOUs. Previous flag and thorough ship particular checks, including, of course, the IMO number, are carried out in order to ascertain vessel identity and that it is not under a sanctions regime or has been reported as fraudulently registered, abusive of another state's flag. And here I would like to mention Assembly resolution on measures to prevent the registration of phantom ships, Assembly resolution on measures to prevent the fraudulent registration and fraudulent registries of ships, and the leg circular recommending best practices to assist in combating fraudulent registration and fraudulent registries of ships. Certain sources and databases are used for performing these checks. The IMO Global Integrated Shipping Information System, the United Nations Security Council Consolidated List, the Consolidated List of individuals, groups, and organizations subject to EU financial sanctions, the EU sanctions map, and databases such as Lloyd's List Intelligence and Equasis. Setting high ship registration standards pertaining to vessels, classification societies, and insurers is perceived by the Cyprus Registry as directly associated with due diligence. No ship is registered in the Register of Cyprus Ships unless classed with the Classification Society, which is a member of the International Association of Classification Societies and is approved by the EU. The Shipping Deputy Ministry has a written agreement with each classification society which governs their authorization to act on the flag's behalf, performs audits and monitors the authorized classification societies, and has an ISO quality control system in place governing their monitoring. In implementing legislation and international conventions on compulsory insurance, the Shipping Deputy Ministry only accepts insurers, P&I clubs, that are members of the international group, and a very small number of prudent and well-established insurers outside the international group that have been approved following a thorough review, taking into account Circular Leg 1, Circular 16, on the guidelines for accepting insurance certificates and insurance providers. Existing online tools that contribute to fraud and abuse of flag prevention are the following online access-free tools available to the public and mainly used by shipowners, seafarers, coastal authorities, and port authorities. On our website, there is a service of online verification of certificates of Cyprus Registry, registration deletion certificates. Civil liability certificates for vessels can be verified online, as well as seafarer certificates. Our Shipping Deputy Ministry is under a process of digital transformation, replacing its current system, the system currently in place. The complete digitalization of our ship registration process will undeniably constitute an additional new tool for enhancing relevant due diligence. In concluding, due diligence on ship registration is an ongoing and challenging process that has become increasingly important due to the safety, security, insurance, and environmental risks posed by today's shipping. International cooperation is required to address this challenge as the shipping industry is global in nature. Further discussions by the IMO Legal Committee on the development of relevant non-mandatory guidelines or best practices on the registration of ships under the new output agreed at Leg 112 may contribute towards these efforts. Thank you for your attention.
Thank you, Lydia, for a very interesting presentation, and I congratulate you as presumably the pivotal person on this very robust due diligence system which Cyprus has. The Romans, with their bonus pater familia, due diligence, would be very impressed. I also would like to thank you because apart from the fraudulent registries, you focus on another challenge, which is the UN sanctions, monitoring and shipping, etc. So thank you very much. Do we have some questions, please? George?
Thank you very much, Professor Judge Attard. It's a pleasure to see you. Let me first start by thanking the speakers for the insights that they provided. If I may, Mr. Chairman, I'd like to start with the facts. Currently, we have 287 false flag ships and about 1,000 vessels which are in a status called unknown flag. Now, this information is extracted from GISIS, a platform which is under the responsibility of the IMO. And as we heard eloquently by Judge Caracciolo, the vessel must have a nationality, must fly validly a flag. Article 92 of ITLOS also speaks about the status of a ship. And no ship can be also in the high seas without having a valid nationality and a valid flag. So my first question, this is actually addressed to all eminent speakers. My first question is, suppose that a vessel which has a false flag enters a port of a member state, and we have a port state control. The officer looks at GISIS and finds that this particular vessel with a particular IMO number has a false flag. Should that vessel be detained? And in the absence of national rules, whether under UNCLOS there is actually a duty resting upon the states, port state, to detain the vessel. The second question is a bit wider. I will be as brief as possible, but I think these matters should be addressed, Mr. Chairman. In case we have a false flag ship, whether such flaw taints also peripheral arrangements and contracts. Just to give you an example, if a vessel flies a false flag, can it validly be classed by a classification society? Can the ship owner conclude validly a seafarer's contract? Can the vessel have, if it's a tanker, a valid insurance cover in respect of its compulsory liability, or whether these are flaws which taint also the agreements? Thank you very much, and congratulations again.
Very pertinent points, Professor. Any member of the panel would like to? Judge Caracciolo, you were referred to.
Thank you for this question. I don't want to do the judge and decide in the case all alone. You proposed a very complicated situation. What I can say is concerning the first question that the arrest and detention of a ship in a port is something outside the scope of UNCLOS, which doesn't deal with internal waters. It refers to internal waters in certain specific case, Article 8 of UNCLOS, concerning waters that before UNCLOS were territorial sea, and then with the expansion of the territorial sea breadth and the UNCLOS have been included in the internal waters, so innocent passage allowed. But this is one of the few references, so it is a issue to be solved, taking into consideration domestic jurisdiction, and you all know that there is a friction between the application of domestic jurisdiction and, on the other side, the attempt by the flag vessel to maintain a sort of autonomy of the vessel within ports. We have opposing case law, domestic case law, since the end of the 19th century on that. And second point, I personally will interpret false registration in a strict manner in order to save in a certain way the protection of those not involved in such fraud. Think about the seafarer or I don't know, debtor, creditors towards the vessel and so on. There is a general principle of interpretation of rule in order to permit the remaining rule, not the, to be applied. So I will try to protect those not involved because of their intentionality or because of their negligence in the fraud committed.
Thank you very much, Judge Caracciolo. Yes, please.
Thank you very much, and thank you to all the distinguished panelists, and also thank you to everyone involved in the IMO Secretariat for making this possible. My questions are more directly towards Judge Caracciolo. You have described the debate that led to the adoption of Article 5 of the Geneva Convention of 1958 and then Article 91 of UNCLOS. But given the recent developments and current dynamics, I was wondering if you could tell us what are your views on the importance of genuine link when it comes to considering the nationality of a ship and the opposability of nationality in this regard when considering the exclusive jurisdiction mechanisms. And also a second question, but maybe there is a very fast answer to the second one, it's just that it popped to my mind. From the UNCLOS and your explanations, it seems that a ship which changes nationality during a voyage can be considered as a ship without nationality, and thus, I guess, may be subject to Article 110 provisions. But I was wondering, for how long does this status go? And if a ship changes flag during a voyage, can it be considered without nationality on a consecutive voyage, or does the stop at a port changes the regime and the situation? Thank you very much.
Thank you very much. Well, I think that the genuine link is connected with the effective exercise of jurisdiction by the flag state, and therefore, which is not a secondary point. You know, the registration or the conferral of nationality upon a vessel is a right, but also it involves duty. Once the flag, a vessel has been registered in a state, that state shall guarantee many aspects concerning the navigation of such a ship. Think about safety and security of navigation. Safety of navigation is something extremely important. Think of, in case of collision, the exercise of penal or criminal jurisdiction towards those having committed the collision, and many other cases, think about, and ITLOS dealt with this case in the advisory opinion on fishery. Think about the duties of the flag state of fishing boats concerning the respect of the rules established by the coastal state in its EEZ in order to maintain the fish stocks and a sustainable fishery activities. So I think that the meaning of genuine link is to highlight strongly that once the flag has been granted, there are many other duties upon the flag states, and they are reinforced by this reference to the genuine link. Yes, a vessel having two flags is considered by Article 92, applying Article 92 as a vessel without any flag. I must tell you that it is not so common, but it happened to me to hear an Italian officer which had the case of a vessel. This vessel was submitted to the right to visit on the high seas in the Mediterranean Sea, of course, and the master, it had a vessel. It showed a vessel, a flag, sorry, and when the officer asked to see the book, the master took out a book of registration which was from another country. So the officer asked, but this is a different country from the flag you are showing. So the master said, oh, sorry, now I will take out the good book, and it was the book of a third country. So this vessel, of course, was considered by the Italian authority some years ago as without any flag. It was involved in illicit traffic of narcotic drugs. And obviously this use of different flags was connected with an attempt to maintain, to confuse, to mud the water in a certain way. The voyage, it's a very vague concept. It doesn't connect, it isn't connected to going from a port to another. There can be multiple stops during a same voyage. I think it is a situation to be ascertained case by case, according to the evidence on the hands on those exercising the right to visit, which must, and you know very well that Article 110 is very cautious because it requires a high level of diligence by the visiting state, and also it provides for a liability, a civil liability, a compensation, not because a wrongful act has been committed, but for illicit conduct by the state. So I think it is a case-by-case control to be conducted. Thank you.
Thank you, Judge Caracciolo. Any other questions? Well, in that case, I would like to thank you for the patience. I will keep you no longer. Oh, yes, there is a question. Sorry, I didn't see it. Thank you.
Thank you. Just a quick one. I know we are all looking forward to the reception. Thank you very much for moderator, and thank you to the wonderful presenters and the panelists. It's very important to note that this is no more gender balanced. I say that they are dominated by women. And so we have to thank the Secretary General for, for promoting women in maritime use. Having looked at, listened to the Cyprus presentation, I noticed there's a part which has the conditions of ownership. And the last part shows non-EU/EEA registered legal entities controlled by EU citizens. I'm trying to assume that this is to fulfill the genuine link requirement as per UNCLOS. I don't know if I'm correct, but having listened to the earlier presentation, I wanted to find out what is the issue of the bareboat charter. How do we link the bareboat charter vessel with this genuine link? What is UNCLOS saying about the bareboat charter? Thank you very much.
Please.
Thank you for the question. Indeed, the conditions of ownership and who can own a Cyprus ship are related to the genuine link. And as we've mentioned, if a non-European Union, European Economic Area company is to own a Cyprus ship, it should be controlled by EU citizens. And we've also mentioned that they are required to appoint and maintain an authorized representative in the Republic of Cyprus. And the same goes for bareboat charterers.
Thank you very much. Then I think we can conclude. I just want to make a comment, and just a comment, provocative perhaps. When we talk about all these issues, we have to remember that under UNCLOS, the right to navigate belongs to the state. And therefore, all these tools are designed to ensure that the state does protect the right to navigate. I know it's basic, but it's good to remember. I thank you once again. I thank you for your last reaction. I envy the lawyers in your country. They are very privileged. And I will not hold you further for the kind reception offered by the government of Cyprus. Thank you.
So, ladies and gentlemen, this brings us to the end of our panel discussion this afternoon. I would like to thank all of the distinguished speakers for sharing their expertise today, and you, the audience, for joining us, whether that's virtually or in the room. And of course, for those of you in the room, you are now invited to the Delegates Lounge for the reception hosted by Cyprus Republic. Thank you. Thank you very much.